Hi, I'm Debbie Moraes, and this is Legal Matters, the program that's been designed to discuss some of the critical and contentious issues that are facing businesses and people today. Legal information, practical solutions, and straight talk about a wide variety of topics that affect our daily lives. In our last session, we discussed contracts, and today we're going to focus on that a little bit more deeply and specifically business contracts. We discussed in the last segment that certainly memories are notoriously fickle, so it's a good idea to have it in writing. Which ones and what should we look at? I think that our two lawyers, our legal eagles, Jackie Grasso and David Bazar from Audette, Bazar, Cordeiro Grasso Law Firm in East Providence, are here to give us a little bit of insight about what to look for and how to evaluate some of these contracts that may come your way. So when we think about sales contracts and employment contracts and also leases, of them, I guess there are certain things that are common to all, even though each one is individual. When you look at, for example, contracts that have to do with sales, what are the kinds of things that you would tell someone to be aware of? And I guess what comes to mind first are the bill of sale kinds of contracts that people often enter into. It's something that probably affects most people. Sure. What kinds of things do you think about that we should be aware of?
Well, first and most importantly, if it's a contract for the sale of goods over $500, it has to be in writing. Okay?
Right.
The statute of
the
frauds.
statute of frauds applies to sales of goods over $500, UCC issue.
My advice there is even if it's for $3, I would put it in writing.
Right.
Yeah.
As we talked about last time,
Yeah.
any contract that even can be made orally is fraught for problems if it's not in writing. So put it in writing. With the UCC, which governs Uniform Commercial Code transactions under that type of situation, some contracts have to be in writing. And here's where it gets to be interesting. The UCC Article 2 sales governs things that are sold, that are goods, as opposed to services. And interestingly enough, in law school, they stump you quite often on whether something is a contract for the sale of goods or if it's for a service. So either way, I would put it in writing.
Is there something called a common law goods or something that is state to state as opposed to
Uniform contract?
Uniform, which is...
Well, the UCC has been adopted in all states.
All states.
So it's going to be the same just about in every state, although there will be some little variances from state to state. The whole idea being that the merchants want to have uniformity, and that's why the UCC was created, so that if you deal with someone in Rhode Island as opposed to someone in California or Michigan or wherever, it's the same rules that apply. So there's, for the most part, uniformity on all rules with some slight little deviations state to state that are not
Simply
important.
put, too, all contracts have to have terms.
Right.
What are your terms of your sale? What are the terms of your service? Of course, you want it dated. You want to know what the sales amount is going to be, so that's also your consideration. That's what you're paying for. So you want to make sure the terms are there. You want to make sure your terms of payment are there. It's got to be signed. Sometimes they might ask for a personal guarantee, depending on the type of contract it is. If there's a personal guarantee, I always tell people we need to get some legal advice about that because they don't always understand what a personal guarantee is, and quite simply, it's you're guaranteeing that you're going to pay for the services or for the goods if your business defaults on the contract.
Right. And to answer your first question, what should a contract for a lease, a sale of goods, or employment contract have?
For example, basics.
It's exactly what
Terms.
Jackie just laid out, the terms of the contract. Who are the parties to the contract? That should be spelled out. If the employer has one entity, but there are other entities that may or may not be involved, you want the parties to be clearly spelled out. Yep. If it's an employment contract, you want the length of the contract to be spelled out, the compensation, the responsibilities, the duties, as Jackie would say, the consideration that's being put forth in the contract, the expectations. If it's a sale of goods, what goods are we talking about specifically? What's the price? What's the delivery point? What are those terms? Lease, what's the length of the lease and what property are we leasing? So those are the terms that should be spelled out in any lease.
So while we're giving broad brush strokes to this, it makes sense that we're going to be delving and drilling down on these a little bit more. But in each case, there is, I guess the reason that people have contracts is there's this element of risk. And while you can speak about each one individually as we go along, there is supposed to be some allocation of risk that we're supposed to be wary of. How do you, in general, be wary of that? And does that just mean the fine print?
Well, the allocation of risk, I think, with regard to an employment contract, if we take them one by one, you have to realize that there are terms in the contract, and if you don't comply with the terms, your risk is you can be terminated for cause. With the sale of goods, if you don't pay for the sale of goods, what's your risk? You could default, and at the same time, you run the risk of being sued for payment on that. On the leases, the risk again.
Well, we can really drill down
Yeah.
on this if you want. On a lease, it's who's going to be responsible if there's a fire?
That's right.
Do I still have to pay my rent if there's a fire? Am I responsible for the fire insurance? So that's an allocation of risk within a lease. As Jackie was saying, with the sale of goods, if I'm buying 5,000 widgets that are being shipped from Kansas to Rhode Island, am I responsible if those widgets get destroyed in transit? That's a risk that can be allocated to one or the other. There's certain terms in the UCC that apply to who assumes the risk and when does the risk pass, when does title pass, those types
It's like
of things.
with the real estate contract, what happens if the house catches on fire before the sales close?
Right.
The
Right.
risk of loss.
Yeah, risk of loss. And that's stuff that can be dealt within a contract. It doesn't have to be the same for every contract.
I'm not sure that this pertains specifically to a contract, but someone's contract it pertains to. Very current situation in Rhode Island, those who were victims of the flood, say in Cranston, they couldn't live in their homes for X number of months because it needed to be cleaned and renovated or refurbished. I think there's an issue about, well, should they be held accountable to pay taxes to a property that is uninhabitable? Is that a contract? Is that an issue between the city and that person who lives in the home, or the city and the federal government, or however whose contract or
Property
issues?
taxes we're
Property.
talking
That's
about.
that's statutory,
Right.
so it's between you and the town.
Yeah, it's taxes levied on your property by the municipality. The municipality will tell you, we calculate out our budget based on what we can project for income from property tax, and whether you can use it or not, you still own the property.
Interesting.
I would not suspect that those folks got rebates on their property tax. Maybe it's a good idea to try. I don't think it would be successful.
I think that's what's going on right
Yeah.
now.
Right.
Often people talk about contracts and fine print. There really is fine print, right?
I think the whole contract is fine print when you stop and think about it.
Sure.
Yeah.
How do you know at what point you should cease looking at that fine print yourself and enlist you folks? Is it just a matter of dollars and cents that we need to worry about? Is that usually the problem?
Well, again, let's go back to statute. You
terms.
have your consumer protection statutes, for instance, for home improvements.
Right.
Certain things have to be conspicuous on the contract, and if it's not, and you later
Right.
have to sue for a term on there, then there's a risk there
Right.
where,
But as a practical matter, I think it depends what you're contracting for. As Jackie's saying, if it's to make home improvements to probably one of your largest assets, if not the largest asset, and it's a significant amount of money, you might want to have an attorney look at that. Those contracts that are, you buy a ticket to go to an amusement park and there's all the fine print on the back of it, I don't think you're going to go hire an attorney to look at the back of that ticket. And in fact, all that little fine print, if it's overreaching and unfair to the other party who has no opportunity to negotiate that, it's called a contract of adhesion. It might not even be enforceable anyway.
one-sided.
Exactly.
Now, for an employment contract, that's a little bit more detailed,
Right.
and I always recommend somebody get legal advice.
Yeah.
Because there are certain terms in employment contracts that you have to make sure your client understands. You have to make sure that it's not an adhesion contract. I've seen contracts like that, and where attorney comes in and they look at the terms, and they may even help you negotiate the terms of the
Exactly.
contract.
Because as Jackie's saying, let's say you're applying for a job that's a fairly significant job at a business that's a large business, and even if it's not, I don't think that really matters. The issue is this. There are some terms that you should be comfortable negotiating yourself. What's my salary? What are my benefits? What's my vacation? Those types of things. What about this non-compete clause that they might put in there? And you're not going to be able to go work for someone in the same type of business.
That's a very big
It's
issue.
always a sticking point, yeah.
there are some contracts that involve employment, some that are mileage, and then some that are not just about mileage. How is someone supposed to defend themselves with a mileage situation when, in fact, companies may have many facilities, or they may be omnipresent and global because they have an internet presence, and where does mileage come in at that point?
So be
how does that
specific
work?
so that it's clear what you're talking about,
The
mileage.
amount of area that
Right.
you're able to...
To trade, what
Okay.
that you
Right.
can't trade within because it would be a
Right.
So getting back to what
competition
David said, it
package.
can't be overreaching. The first thing you have to understand is if it's a contract for employment in Rhode Island, anything can be overreaching in terms of mileage because you can drive through the state in less than an hour,
yes.
Right.
okay?
Yes.
So if you have an employment contract with a non-compete that says you cannot work within 500 miles of the state of Rhode Island, that's overreaching.
Right.
And I don't think the court would enforce that.
Again, you're right, depending on what the business is.
Yep.
So that you have to be protecting a legitimate business interest.
Yep.
So if you're working for a restaurant, say,
Yeah.
what's the range of business that people would go to in Rhode Island for a restaurant? Well, my friends who live in Providence sometimes won't even drive to East Greenwich. However, it might be fair to say within 20 miles of that restaurant, you can't open up a competing restaurant. But if it were a business something that's more far-reaching, that, as Jackie's saying, that area is
Sales?
not...
About sales?
Sales,
Yeah.
right. Door-to-door salesman or
Sales,
something.
yeah, you might have a territory, and your non-compete will say, if you're no longer working for us,
Right.
you cannot sell in this area, in this
Right.
location. So I think 300, 400 miles is somewhat unreasonable, somewhat excess, because
Right.
now you're taking somebody's ability to earn, you're taking that away from them.
Right, but to go back...
do you defend that
Well,
then?
here's, to go back to what you said, it has to be
Legal way comes in,
reasonable.
yeah.
We've had cases that we've had to
Oh, yeah.
defend and say, okay, let's suppose we're representing the employee, and he sells something, and the company he's selling for, the widgets, let's go back to, they sell their widgets within a 300 or 400 mile territory, and they can show, here are customers that we've had. Well, if the contract says 1,000 miles, that's not reasonable. So the court can either reduce the mileage and say this is what's reasonable, or they can eliminate it altogether.
So this needs to go to court, though.
That doesn't need to, it can be negotiated, but it could go to court.
But you can negotiate that. I've seen them be litigated.
Sure,
and,
we've gone to court with those things.
If someone is a bartender in Providence, and that's what they're trained to do, could they likely be held to a non-compete because there's a restaurant in Providence and then they go to another restaurant in Providence and another restaurant, which is very likely. Is it reasonable that an employer can ask that employee to sign a non-compete and tell them that he can't go to do his job not across the
I
street,
think,
but in that territory? Is that
I don't think,
defensible?
no, that's not reasonable, especially if it's somebody who's not in a management position.
So there's an issue about the level of the
That's usually,
work. Yeah,
exactly.
yeah.
What level of management do you have? What kind of control do you have over the business? What information of our business do you have that might be sensitive that you could take advantage of? These are all things that go into that. I would suspect that there's very few bartenders in Rhode Island who have non-compete clauses. And if they do,
That's probably true.
then they should get some consideration for that.
That's right.
You want me to give something up? You're giving something up. If you're giving up the right to work within a certain area for a certain period of time, the time frame has to be reasonable too. And as Jackie said initially, courts look at these things very carefully and with a bit of a jaded eye because you're taking away somebody's right to work and earn an income. If you're going to do that, there better be some valid consideration on the other side.
Are you talking about money?
Money?
Oh, yeah.
Yeah.
Now, I guess the other side of this too is when someone is interviewing for a job, the thought would be, if this is going to be part of the contract, isn't it better to negotiate and discuss that beforehand, maybe change what the terms of that employment agreement or contract is, rather than having to battle it out later on? Always better beforehand rather than having
Yeah.
to...
Well, yeah, you want
it later?
before they reduce it to a writing, you want to make sure that there's a meeting of the mind, that there's an agreement between the parties, so those